Next, let's take a look at question 3. Congress enacted a statute providing that persons may challenge a state energy law on the ground that it is in conflict with the federal Constitution in either federal or state court. According to this federal statute, any decision by a lower state court upholding a state energy law against a challenge based on the federal Constitution may be appealed directly to the U.S. Supreme Court. The provisions of this statute that authorize direct United States Supreme Court review of specified decisions rendered by a lower state court is constitutional, because Congress may establish the manner in which the appellate jurisdiction of the U.S. Supreme Court is exercised. B is the best answer because it correctly identifies that Congress has control over the Supreme Court's appellate jurisdiction. Under Article 3 of the Constitution, Congress is given the power to regulate appellate jurisdiction of the Supreme Court. The only limitation on this power is that Congress could not authorize the Supreme Court to take jurisdiction or perform any functions beyond those provided for in Article 3. And incidentally, Congress can't fool around with the Supreme Court's original jurisdiction, only its appellate jurisdiction. Here, Congress wants to include lower state court energy cases where a state statute conflicts with the Constitution in the Supreme Court's appellate jurisdiction. These are cases, so the law would not violate the case or controversy requirement of Article 3, Section 2. Plus, since the cases involve a federal question, they are within the bounds of Article 3's federal jurisdiction requirements. Thus, Congress could expand the Supreme Court's appellate jurisdiction to include these cases. Because option B recognizes this, it's the best answer. A is wrong, because the issue is jurisdiction, not the substantive issue of energy use. C is incorrect, because the existence of a conflict with the Constitution means the law does not infringe improperly on state power. What is at issue here is not the states' rights to review their own cases, but rather the power of the federal judiciary to review cases where there is a conflict involving the U.S. Constitution. And that's an area which, contrary to what this pick states, there's no sovereign right of states to have their own Supreme Courts review cases. D is incorrect because it misstates the Supreme Court's appellate jurisdiction. Congress could expand the Supreme Court's appellate jurisdiction to include these cases. The best answer to question 3 is B. Next, turn to question 4. Here, Congress enacts a law providing that all disagreements between the U.S. and the state over federal grant-in-aid funds shall be settled by the filing of a suit in the federal district court in the affected state. The judgment of that federal court shall be transmitted to the head of the federal agency dispensing such funds, who, if satisfied that the judgment is fair and lawful, shall execute the judgment according to its terms. This law is unconstitutional because it vests authority in a federal court to render an advisory opinion. D is the best answer because it correctly identifies that Congress cannot enlarge federal court jurisdiction to include advisory opinions. Article 3, Section 2 of the Constitution gives Congress the power to create federal courts beneath the Supreme Court and also the power to determine the jurisdiction of those courts. However, there's a limitation on this power. Congress cannot expand federal court jurisdiction beyond the boundaries prescribed by Article 3. The case and controversy requirement is one of these boundaries. Federal courts can only render advisory opinions. They can never render advisory opinions, and they can only render any kind of an opinion where there is an actual controversy. That is, the matter in controversy must be definite and concrete. It must touch the legal relations of the parties having adverse legal interests, and here's the key, there must be a real and substantial controversy capable of specific relief through a decree of a conclusive character. A is incorrect because it fails to recognize that the statute expands federal court jurisdiction beyond the boundaries of Article 3. That makes it invalid. B is wrong because it misstates the law. Congress can set up tribunals to resolve disputes, but it cannot use Article 3 courts to do it. To do so would require federal courts to issue advisory opinions, and Article 3 prohibits that. Option B doesn't recognize this, and that's why it's wrong. Finally, C is incorrect because the 11th Amendment would not bar suits under this statute. Generally speaking, the 11th Amendment bars a citizen from suing a state in federal court without the consent of that state. Generally, the only suits that are prohibited are those which would require a federal court to award money damages for past conduct, where the damages will be payable from the state treasury. The 11th Amendment does not bar federal court suits by the federal government against the states. The best answer to question 4 is D.